Hello, my beautiful, beautiful people. How are you? Are you ready to dig into the second part of our series here on the latest filings of Zellner, the post-conviction lawyer for Stephen Avery? Now, if you're unfamiliar with who Stephen Avery is, he was wrongfully convicted and served 18 years in prison. When it was learned through the Innocence Project that it had been suppressed intentionally, that another inmate had actually committed the crime, Stephen was exonerated. And in doing that, he began to sue the state of Wisconsin in the upwards amount of $36 million. As this amount started off small and continued to grow to a larger and larger suit, the depositions were being had by for all those that, from the bottom rung all the way to the top. We're down to the last two most important people, which is, the deputy sheriff, the sheriff of that county, as well as the DA. And their depositions are to be had, but everything is looking really pretty much like Stephen has won. Now, I highly doubt he would have got $36 million, probably $10 million. Who knows? But this went far deeper than money because Stephen Avery had been a junkyard dog in their eyes, allegedly, and had come up shaking hands with politicians and making this county look like it was showing its ass. And so it got to be a pissing match. In this, as we come down to the final day, there's a law passed called the Avery Bill. Now, this bill was named after Stephen Avery, and it could very much apply and needs to apply to all cases, including the Idaho 4. And the Avery Bill was a law that would be passed that said you cannot target one individual as a suspect when there are multiple directions of DNA and evidence. You have to follow through with all of them, and you have to do your due diligence and uphold the law and investigate all suspects. You can't just be like, well, this is the one we choose and this is where we're going. And that was the Avery Bill. Now, interesting enough, the Avery Bill got swiped at the very last second. When I say the last second, by the end of the day, it would have been finalized as the Avery Bill. But the Attorney General, who was one of the ones that was having the pissing match with Steve Avery, all over money, it looked like, but it wasn't. It was over, like I said, Steve Avery was shaking hands with some bigger and bigger politicians. And he was starting to get some suits on his side that there was some corruption. And, well, we just can't have corruption uncovered, right in front of the public eye, right? And so on the morning before this individual disappears, the bill is swiped by Peg Lautenschlager, the Attorney General at the time. All right? It's then renamed, and the board is swiped clean, all except for two board members. Norm Gahn, which, if you're familiar with this case, you're like, isn't he the one that made the law that said you can't give away any biological evidence or anything like that? You got to protect it if it was used to convict someone until they're free. But then he gave away the bones in the case that were used to convict Stephen Avery. And I'm like, yes, that guy. And then the other one is Jerome Buting, which ended up being Stephen's lawyer, which to this day I cannot swallow. I don't care what you guys want to tell me about how wonderful he is. Stephen's still sitting in prison, and these fellas are making money all over, doing their talks, and they look like a flower, but to me they're a weed. Okay? Just saying. And so we don't get the bill passed. It gets changed, new name. a girl that had been going out there and taking pictures of the used cars and putting them in Auto Trader magazine for sale, named Teresa Halbach, who was a 25-year-old photographer, disappears. And we're in court. We've got Bobby Dassey, star witness, Stephen Avery's nephew. Now that house over there where Bobby Dassey lives, they've got every boy with a B. They've got a Brendan, they've got a Bobby, they've got a Brad, and I can't remember the other guy's name, but it's with a B. So they're all B boys, the BB boys, right? Now, Bobby is about 19 at the time all this takes place, and Brendan, I think, is 16. And then there's a younger boy, Blaine. There we go. Anywho, this all is taking place and coinciding within a month of the Christine Rudy case. So keep that in mind. That's where we're going to be looking into as we move forward in this case. But tonight we're going to be reading how it turns out that the star witness of the Stephen Avery trial, which was Bobby Dassey, the 19-year-old brother that lived kitty corner on the almost the same parcel of Stephen Avery's trailer. He was a star witness. In this, you're going to hear the post-conviction defense attorney speaking of how there are witnesses, a witness, Mr. Zawinski, who saw Bobby Dassey pushing the victim, Teresa Halbach's vehicle at night, or early in the morning, I should say, still dark out, 2 days after she's gone missing. And guess what? They find that vehicle that day. And all the evidence that they have on Stephen Avery, other than a key found in his trailer, after 8 searches, and then the county that is being sued by Steve Avery, it's their guys that find the key that nobody else could find. All right, so the rest of it's all in the car. So we're gonna find out that really honestly, we're in a traffic jam in the courts because we can't seem to get it through their thick skull from a post-conviction standpoint that we're not here to at this moment, we're not supposed to be putting all that we know and all that we can prove on the table. We're simply supposed to give you the information that we have, the new evidence, and we will prove it, but we need to get in court to do it. We're not going to do it in this little letter. That's not how law works. So we're asking for an oral hearing, an evidentiary hearing, something to that effect. And that's what we're here for. So that, I hope, helps those that are, Big Mama D followers, big 1111 family members, been here a long time, and quite, not sure exactly how this case all went down. All right? So, without further ado, now going forward, I'm not going to go into the history every time. We're just going to, because we're probably going to have another live. This thing is a very long filing. But how is everyone doing? Riding solo. Katie Bug. Sassy says, this goes back to 1985 when they took away his ability to be a father to his twins, and those lies distorted the way his children viewed him, too. Very sad how deep this all goes. Yeah. I think they were 6 weeks old, or 2 weeks old, maybe even 3 weeks old. I don't know. Twins, little boys. Hi, Monique. How are you? Dreamweaver? Running solo. Sarah Pagan, hello. Interior Family Studios, Karen Guy. Hope I didn't miss anybody. Hi, Rose Hyde. How are you? Deborah Van Winkle says blessings and prayers for families and for those whose channels are shown for all the lost souls that need justice. Aw, so beautiful. Thank you. Hi, Jeff. How are you? June Coggin, Tracy Gear, Cynthia Codwell, Night Nurse, and the rest of you as well. All right, let's get rolling. What do we need to do here? There it is. Okay, let's get rid of the thumbnail. Let's go browser. There we go. Can you see okay? And can you hear okay? Soon as I see a 1 in chat, we will roll. We're starting on page 19. This is, hold it, Jeff. This is the state of Wisconsin versus Steve Avery on appeal from the order denying post-conviction relief entered on August 22nd, 2023. And so this reply was filed on January 12th of 2024. All right. So where were we? 19? Something like that. Yep. Okay. We're on issue C. Are you guys ready? All right. Thank you, everyone, for joining. And let's get rolling. C. Argument. The circuit court found that Mr. Avery satisfied all the elements required to admit his newly discovered evidence, quote, parentheses, the Zawinski evidence, but for the materiality requirement of Edmonds. The circuit court imposed a new Denny requirement that Mr. Avery must establish that Bobby had a motive, established by conclusive evidence, to commit the murder of Miss Halbach to meet the Edmonds materiality requirement. Specifically, the circuit court states, a review of the record and the defendant's argument reveal that he has failed to satisfy the third standard of the Edmonds test, as well as a motive element of the Denny test. With respect to the Edmonds test, the defendant argued that the evidence offered was material to an issue in the case because it established that there was a viable third-party suspect that could have committed the murder of Miss Halbach. And such evidence was never presented to the jury for consideration, undermining confidence in the verdict reached. In order to meet that burden, the defendant had to prove that the evidence also met the standards set forth in Denny to be admissible as proof of a third-party suspect. The defendant failed to establish that Bobby had a requisite motive to commit the murder of Miss Halbach. Stop right there. Y'all, every case I've ever heard of where they don't even know the motive why the woman's dead, what has it always been? Some sort of sexual whatever, right? So this is stalling. First of all, yes, the original context of the Denny law, which is applied at trial, they had first created for Stephen Avery's case. In other words, there was not a court ever had a Denny law until the first time they used it was in the Stephen Avery case. What is the Denny law? The Denny law means that unless you can prove the means, the opportunity, and a motive, so you have to have access, opportunity, motive, to be able to do this. And so Stephen Avery's team came back to him and was like, you want to accuse Bobby Dassey, and you want to accuse Scott Tadich and Mike Osmondson, and you want to accuse all these people because you got like 45 of them all the way down to the axe guy, right? What was his name? Martinez or something? Martino? Andrea Martino or something? I can't remember. But in order to do that, Stephen Avery, you're going to have to provide a motive. And Stephen said, because he don't know what he's doing, but he's got counsel, right? That's their job. All right. So he says, well, they don't have a motive for me killing this girl because God knows I got $36 million coming. I sure the hell ain't going to screw it up now and hurt nobody, right? I mean, he didn't say that, but that's the concept. Well, they went back and they were like, oh, he says he's not going to give a motive, knowing damn well that was like sealing the cave, burying yourself in. You're not going to dig out. Not alone. You may never dig out of that. Because now you can't point the finger at nobody else. All you can do is say, I didn't do it. Well, how come how come we're supposed to believe you didn't do it? Well, because I found out so and so did it. Oh, no, you can't talk about that. Okay? So it's important. Here we go. Now they've amended the Denny law and made new rules for post-conviction as well. In the middle of the game, kind of like playing checkers, and you finally get your checker all the way to the other board, and you're going to get kinged, and the guy's like, oh, no, 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 no. You have to have 3 of them get over here. The third one gets kinged, and you're like, uh-huh, I see. You're changing the rules as we go. Got it. According to the circuit court, Mr. Avery would have to satisfy 2 tests for the circuit court to admit the affidavit of Sowinski into evidence. The circuit court improperly found that the materiality of Mr. Avery's newly discovered evidence is exclusively contingent upon its satisfaction of the Denny test for admissibility of potential third-party suspect evidence. In determining that Mr. Avery's new evidence could only be material to the issue of a potential third-party suspect, the circuit court completely ignored the inherent materiality of Sowinski's evidence to the other material issues in Mr. Avery's case. So they ignored the point. In Mr. Avery's third motion of post-conviction relief, he argued, the Sowinski evidence is material to several issues in Mr. Avery's case. It is material for establishing Mr. Avery's defense, that is, that a third party committed the crime against Miss Halbach. Additionally, the Sowinski evidence is material to the evidence in the RAV4 being planted by Bobby, including Mr. Avery's blood and DNA. The RAV4 also contained the Halbach vehicle key and Miss Halbach's electronic devices, which were discovered in Mr. Avery's bedroom and burn barrel, respectively. Further, the Sowinski evidence is material to impeach Bobby's trial testimony that Miss Halbach never left the Avery property and that she was last seen walking toward Mr. Avery's trailer. Let me wet my whistle, you guys. Okay. The new evidence showing that Bobby had possession of Ms. Halbach's vehicle is highly material for evaluating the reliability of the forensic evidence used against Mr. Avery, which all happened to be derived from Ms. Halbach's vehicle. Crucially, it is also material to the reliability of the state's key witness against Mr. Avery, Bobby himself. This court points out in paragraph 4 of its opinion from July 28, 2021, quote, the state's theory was that Avery shot Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned the electronics and camera, cremated Halbach in the burn pit, transferred the remains to a burn barrel, and hid the RAV4 until he could crush it in the Avery car crusher. Mr. Avery's new evidence shows that the vehicle did not leave the Avery property and was in possession of a third party. Additionally, the new evidence debunks the state's theory against Mr. Avery that he kept the RAV4 on the Avery property by the crusher so that he could crush it immediately. The evidence of Bobby's possession of Miss Halbach's vehicle is material because it shows that Bobby had possession of the forensic evidence used to convict Mr. Avery. The vehicle was a crime scene by virtue of having all of the relevant forensic evidence in it, including Miss Halbach's blood. The Sowinski evidence establishes that Bobby, the state's star witness, had control of the crime scene for a period of time. Despite police searches preceding the discovery of Miss Halbach's vehicle, Miss Halbach's electronic devices and key were not found until after Miss Halbach's vehicle was found. The only logical conclusion to explain this is that all the items remained in Miss Halbach's vehicle and were then moved by whoever had possession of her vehicle. If a third-party suspect had possession of Miss Halbach's vehicle, numerous areas of reasonable doubt arise, such as that the forensic evidence in the vehicle is tainted by the third party having control of it before it was discovered by law enforcement on the Avery property. This would have created reasonable doubt in the jurors' minds, particularly since the state's star witness was the one in possession of the vehicle. Thus, Mr. Avery's new evidence also presents an alternative theory for the source of the forensic evidence used against Mr. Avery. C. Edmonds. How y'all doing? State versus Edmonds. For those of you that aren't used to these filings, when it tells us another case, it's literally going to tell us about the case of the Edmonds, okay? Or, Navarro, or whatever case it is. So, State versus Edmonds is the leading case on newly discovered evidence. In Edmonds, the defendant was convicted of the death of an infant she was carrying, for at the time of the infant's death, the defendant filed a motion for a new trial over a decade after her trial and offered medical testimony that showed there had been a shift in mainstream medical opinion as to the cause of the types of injury the infant suffered. The court found that the evidence was material to an issue in the case because a main issue at trial was the cause of the infant's injuries, and the new medical testimony presented an alternate theory for the source of those injuries. So it's all about that alternate theory, right? When evidence comes available and it provides an answer, because before you're like, well, it only leaves this as an answer. And so that's what the jury thinks. Well, I can't think of another answer. That seems logically it, and this is my decision. But now, this is new evidence. Now, if the jury had heard that Bobby Dassey had been pushing Teresa Halbach, the victim's vehicle, up the damn driveway to park it near the crusher, do you think when he pointed at his uncle and said, he's the last one that saw her alive, I saw her walking toward my uncle's property, when he said those kind of things, do you think the jury would have went silent on death and been like, oh? Or do you think they might have thought, so you saw her last then, really, right? Might have thought we have the wrong guy in the hot seat. Here, applying Edmonds, Mr. Avery's new evidence is material to a key issue in the Mr. Avery's case because Mr. Avery's new evidence that Bobby had possession of Miss Halbach's vehicle after her murder presents an ulterior theory for the source of the evidence used to convict Mr. Avery. The Zelinsky evidence is additionally material because it completely calls into question the reliability of the state's key witness, Bobby's testimony, which allowed the state to argue Mr. Avery had conclusive control of Miss Halbach and her vehicle, which contained all the forensic evidence, and that this evidence was not tainted by any third party. During its closing argument, she referred to Ken Kratz as it. Okay, during its closing argument, the state emphasized the importance of Bobby Dassey's testimony and vouched for his credibility. Quote, again, an eyewitness without any bias. It is an individual that deserves to be given a lot of credit. With the new Zelinsky evidence, as well as Mr. Brownlow's affidavit, the state could not possibly have presented Bobby to establish that Miss Halbach never left the property in her vehicle and that she was last seen walking toward Mr. Avery's trailer. The state's critical witness linked to obtaining Mr. Avery's conviction. Clearly, By Bobby possessing the Halbach vehicle, there is a reasonable likelihood it would have affected the judgment of the jury and that Bobby would have emerged as more likely a suspect in the murder of Miss Halbach than he recently released, wrongfully convicted. Why does that say? Recently released, wrongfully convicted uncle. Oh, because of the previous conviction. Okay, that threw me. Woo, that is some weird writing. I'm like, recently released? He's recently released? She's talking about at that time he had just got out of prison after being wrongfully convicted on that time. Because we've got double jeopardy in my opinion, but whatever. I'm not a lawyer. I do not play one on TV either. Bobby was biased and deserved no credit for his fabricated testimony. The United States Supreme Court in Weary. Brady applies to evidence undermining witness credibility. Evidence qualifies as material when there is, quote, any reasonable likelihood it could have, quote, affected the judgment of the jury. To prevail on his Brady claim, Weary need not show that he, quote, more likely than not, would have been acquitted had the new evidence been admitted. Additionally, in regard to a motion for a new trial, a reasonable doubt as to a defendant's guilt has been found to exist when the reliability of the witness critical to the state's case is completely called into question by newly discovered evidence. State v. Wilson, quote, a new trial is required if the false testimony could, in any reasonable likelihood, have affected the judgment of the jury. Damn, she nails it. Oh, I love this. Wisconsin law has long held that impeaching evidence may be enough to warrant a new trial. In State v. Plude, the defendant presented newly discovered evidence that an expert witness lied about his credentials. The Supreme Court of Wisconsin found that because the expert witness's testimony was a critical link in the state's case, the expert witness's quasi-medical expert testimony creates a reasonable probability that the jury hearing a false testimony about his credentials would have had a reasonable doubt as to Plude's guilt. Notably, in Justice Annette Ziegler's concurrence with the majority opinion, she wrote that, quote, the new allegations that the expert witness misrepresented his credentials about his affiliations and work experience created a, quote, serious question as to whether the interests of justice were served. Here, Mr. Avery presents a strong case about the materiality of his newly discovered evidence because he does not just allege that it shows that Bobby misrepresented facts in his testimony. He alleges that the Zelwinski evidence shows that Bobby committed perjury in his testimony, that he left the property and did not see Miss Halbach again. Furthermore, the newly discovered evidence taints all of the forensic evidence used against Mr. Avery, which resulted in his conviction. In this court's previous opinion on July 28, 2021, the court did not believe that the impeachment of Bobby was material because it found that there was significant forensic evidence linking Mr. Avery to the crime. However, the Zelwinski affidavit establishes Bobby's possession of the Halbach vehicle, undermines confidence in the reliability of the forensic evidence used against Mr. Avery. This strengthens the materiality of the impeachment evidence against Bobby. In his motion for post-conviction relief, Mr. Avery satisfied Edmonds. Once the four criteria of newly discovered evidence have been established, the court looks to whether a reasonable probability exists that a different result would have been reached in a trial. The reasonable, is that right? Yes. The reasonable probability factor need not be established by clear and convincing evidence as it contains its own burden of proof. Edmonds. With regard to a motive for a new trial, the correct legal standard when with regard to a motion for a new trial, the correct legal standard when applying the, quote, reasonable probability of a different outcome criteria is whether there is a reasonable probability that the jury, looking at both the old and the new evidence, would have reasonable doubt as to the defendant's guilt. Also suplued, as court reviewing newly discovered evidence should consider whether a jury would find that a newly discovered evidence had a sufficient impact on other evidence presented at trial that a jury would have a reasonable doubt as to the defendant's guilt. Here, the circuit court again failed to analyze Mr. Avery's evidence under the proper test because of its improper requirement that Mr. Avery satisfy the Denny motive prong in order to show the materiality of his evidence even for purposes of Brady. Let's take a breath. I feel like I'm back in auctioneer school learning how to talk fast. The circuit court did not dispute that the prosecution had suppressed the audio recording of Mr. Sawinski's call. Rather, it disputed the materiality and favorability of the evidence to find that Mr. Avery failed to establish a Brady violation with respect to the Sawinski evidence. Rather than making the required finding that there was no reasonable probability that a jury hearing Mr. Avery's new evidence could have a reasonable doubt as to Mr. Avery's guilt, the circuit court engaged in weighing the evidence of the violent porn found on the Dassey computer and concluded that the evidence does not conclusively show that it was solely acquired by Bobby on the computer. Let's take a breather. Let's talk for a minute. Interior Family Studios, KC is awesome. Yes, she's nailing this one. Sarah Pagan saying Bobby did it. She also says maybe Bobby was mad at Stephen getting money and he wasn't. Or maybe it was Mike O, you guys, who hated Stephen with a passion because he had been seeing Marie and they were having a fling. And Steve went and bought Marie a trailer to keep her away from Mike because Mike was no good for her. That's Bobby Dassey's bestie. They're bestie friends. And so, the hatred began to fuel like the Hatfield and the McCoys. And I'm telling you now, it got so very ugly between the two. A year before Teresa Halbach went missing, one of the Dassey boys' well, we'll just say the mother owned the vehicle. Her vehicle went missing. Steve drove it a lot, but it was a few miles down the road on Xander Road. I believe it was Xander Road. And it was completely engulfed in flames. Yeah. And so what that did is that allowed the police officers, the law enforcement, the same county that he was suing, to get in there and ask a lot of questions and get to know these boys. Get to know if they buckle under pressure, how they handle stress, what their weak points are, and what their strong points are. They got to investigate every single person that they investigated later in the disappearance of Teresa Halbach. So it was like a dry run, right? And then it was almost as if they were like, okay, we're going to make it look like, he was practicing something here. So, Sassy says, or he just agreed to help frame his uncle and that makes him look guilty. Karma. Sarah says, karma is a B. All right, you guys, here we go. How are we doing on time? We're doing good. What are we on for page 26? Not bad. We'll be doing this a few nights. We'll go for another 20 minutes. About 20 minutes. Interior Family Studio says, I believe that Bobby was angry with TH because she refused to list Bobby's blazer, which wasn't properly registered. That too. Right? Number 3. Whether the circuit court erred when it did not correctly apply State v. Denny, 120 Wisconsin, blah, 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 to Mr. Avery's potential third-party suspect evidence. In his motion for post-conviction relief, Mr. Avery presented evidence implicating his constitutional right to present a defense that a potential third party committed the murder of Miss Halbach. However, The circuit court did not correctly apply Denny to the admissibility of Mr. Avery's evidence of a potential third-party suspect. It erroneously imposed a substantial certainty requirement upon Mr. Avery's evidence and completely misapplied Denny in its evaluation of whether Mr. Avery's evidence satisfied the Denny elements of motive, opportunity, and direct connection. Right? A. Standard of review. This court generally reviews a trial court's decision to admit or exclude evidence under an erroneous exercise of discretion standard. However, when a defendant's constitutional right to present a defense is implicated by the exclusion of evidence, the decision not to admit the evidence presents a question of constitutional fact that this court reviews de novo. B. Burden of proof. On a motion for post-conviction relief pursuant to Section 974.06 stats, the defendant has a burden of proof of Section 974.06 stats and must show his entitlement to relief by clear and convincing evidence. Argument. Denny governs the admissibility of potential third-party perpetrator evidence in Wisconsin. Denny requires a showing that, quote, there must be a legitimate tendency that the third party could have committed the crime. A, quote, legitimate tendency is demonstrated where the defendant can establish 1. Motive, 2. Opportunity to commit the charged crime, and 3. Provide, quote, some evidence to directly connect a third person to the crime charged, which is not remote in time, place, or circumstance. Stop right there. Okay. Motive. Let's talk about motive. Why would Bobby Dassey have a motive? Let's get into it. What do you guys think? What would Bobby Dassey's reason be to kill Teresa Hallmark? Sarah says to get him, to frame Stephen so the state doesn't have to pay the lawsuit. But I mean, why ruin your life so the state doesn't have to pay the lawsuit? To me, that's not it. I think somebody else did this. I think Bobby was the accessory. That's the truth. I think he was at the beck and call of his very bestie. Ah, good one. Sassy says, rejection. Where did he get those claw marks on his back? Because that wasn't no puppy. He had physical scratches down his back. And why didn't he just say, oh, it was from my girlfriend? Couldn't. He didn't have one. Okay? And so when we really look at the situation, you have to wonder, how much of a real part did Mike O play? Mike O is a big hunter. Mike O is the one teaching Bobby how to bow hunt. That day, October 31st, 2005, is the first time Bobby is going bow hunting, you guys. Guess what? You don't go alone the very first time. Who's he going with? Come on. Okay. C. Argument. Denny governs the admissibility of potential third-party perpetrator evidence in Wisconsin. Okay, we did that. In its opinion dismissing Mr. Avery's motion for post-conviction relief, the Circuit Court acknowledged that the standard for evaluating the admissibility of evidence of a third-party suspect is set forth in Denny. However, rather than applying the Denny standard, the Circuit Court applied a stricter standard, which Wisconsin does not follow. In Denny, the Wisconsin Court of Appeals rejected the standard set forth by the California Supreme Court in People v. Green. Specifically, the Denny court agreed with the, quote, the Green Court's conclusion that such evidence must be substantial, stating, We perceive this to be too strict a standard for the admissibility of such evidence and conflicts with our Supreme Court's pronouncements on the fundamental standards of relevancy. She just nailed it, you guys. Slam dunk. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable and less probable than it would be without the evidence. This rule does not say that the evidence must tend to prove a fact in a substantial way. Rather than requiring any level of substantial certainty, Denny adopted the standard set forth in the earlier Supreme Court, Alexander versus United States. There, the Supreme Court fashioned the, quote, legitimacy tendency test, where the standard for evaluating the evidence is that it must show a legitimate tendency that the third party could have committed the crime. In adopting the Supreme Court's test for materiality, the Denny Court elaborated, quote, we believe that to show legitimate tendency, a defendant should not be required to establish the guilt of the third persons with the degree of certainty requisite to sustain a conviction in order for this type of evidence to be admitted. She's deadbolted them out. They can't do shit about this. If the circuit court had correctly applied Denny, it would have found that Mr. Avery has provided sufficient evidence to satisfy the standard set forth by Denny. The Denny court differentiated between evidence which supports a legitimate tendency and evidence that simply affords a possible ground of suspension against another person, which is merely evidence, quote, tending to show that hundreds of other persons had some motive or something against the deceased. I think it meant animosity, but I can't tell you. It's like cut off there. Denny at 623. Unlike the inadmissible type of evidence that the Denny court described, Mr. Avery's evidence is very specific to Bobby and established a direct connection between Bobby and the crime. See Denny at 624. Hundreds of other persons did not have possession of Miss Halbach's vehicle and also have photographs of young mutilated females on the computer of which they are the primary user. The legitimate tendency test asks whether the preferred evidence is so remote in time, place, and circumstances that a direct connection cannot be made between the third person and the crime. Again, Denny does not require a conclusive showing of Bobby's guilt. Rather, it establishes a standard for establishing a potential third-party suspect, which is a material issue in any murder case. Denny states that, quote, as long as motive and opportunity have been shown, as long as there is also some evidence to directly connect a third person to the crime charged, which is not remote in time, place, or circumstance, the evidence should be admissible. Where Mr. Avery has pro-offered evidence that Bobby Dassey had possession of Miss Halbach's vehicle after she went missing, had most likely been conducting computer searches relevant to Miss Halbach's murder, and was on the Avery property before Miss Halbach's disappearance and after her disappearance, no reasonable tier or fact correctly applying the law would find that Mr. Avery has not established some evidence directly connecting Bobby to the crime charged. How you guys doing? Woo! He's seeking rainbows. All right, lovelies. Let's continue. I want to put as much in as we can. Number one, the circuit court erroneously evaluated the motive, opportunity, and direct connection elements of Denny. As this court pointed out in its opinion previously, the evidence in support of Denny must be viewed in the aggregate. Rather than viewing Mr. Avery's evidence in the aggregate, the circuit court required Mr. Avery to present conclusive proof to satisfy each prong individually. However, quote, each piece of a defendant's pro-offered evidence need not individually satisfy all three prongs Further, the Wisconsin Supreme Court has determined that the strength and proof of one of the prongs may affect the evaluation of the other prongs. The circuit court completely ignored these well-established principles of law in evaluating the motive, opportunity, and direct connection elements of Denny. Number 2. Motive element of Denny. In Mr. Avery's motion for post-conviction relief, he alleged that the motive attributed to Bobby for Miss Halbach's murder could have been sexual and provided evidence supporting this, namely the suppressed evidence from a computer that was in Bobby's bedroom, according to his brother Blaine's affidavit. Bobby was the primary user of this computer. Bobby lied to police about the location of the computer, claiming it was in the living room, but crime scene footage showed it was in his bedroom. The computer was examined and revealed searches highly relevant to the murder of Miss Halbach, which occurred during times in which the state had been unable to rule Bobby out as having conducted them. The state argued that other members of the Dassey household could have conducted the searches, a supposition that may or may not be true, but no other member of the Dassey household was spotted by a witness with Miss Halbach's vehicle shortly after her disappearance. Bobby's possession of the vehicle, with all of the forensic evidence used to convict his uncle, combined with the violent pornography searches on the computer in his bedroom, of which he is a primary user, elevate him to the level of a Denny third-party suspect. Oh, yeah. The circuit court spent 12 pages of its 31-page opinion weighing Mr. Avery's motive evidence, which is improper and contrary to the law of motive. The issue is whether the pornographic searches on the Dassey computer are relevant to motive regardless of the weight. In its opinion, the circuit court noted, quote, the state further disputes the defendant's conclusion that law enforcement considered pornography or sexual assault as a motive for the murder in this matter. In dismissing Mr. Avery's motive evidence, the circuit court adopted this erroneous position from the state's response brief. However, this point is completely refuted by the record. On March 10, 2006, the state filed an amended information against Mr. Avery, adding a charge of sexual assault among others. This amendment charge was the result of Brendan Dassey's, quote, confession. On March 1st, 2006, Mr. Avery's trailer and his computer were searched extensively for pornography and none was found. Detective Belly was asked to generate a report of Mr. Avery's computer. Based on Detective Belly's report, no apparent searches of pornography and or sexual images were made, and no websites with apparent sexual and or pornographic images were accessed. In further search of evidence to support a sexual assault motive, the Dassey computer was seized by law enforcement on April 21, 2006, and an affidavit for search warrant for Dassey's computer, Special Agent Tom Backbender. I'm sorry, I have a terrible time with names. Tom Bass Knee Toucher Bender, Fassbender. Your appeant believes that said computer may contain images, records, and messages which may be relevant to the investigation in the homicide of Teresa Halbach. Your affidavit further believes that information contained on said computer, quote, may include evidence of the crime of homicide, mutilated corpse, and sexual assault. Again, the circuit court misstated the evidence by relying on the state's misinterpretations that the investigation was not focused on a sexual motive. Law enforcement made great efforts to extract all the pornography from the Dassey computer and even went so far as to have Detective Belly conduct specific word searches related to the murder in an effort to connect the pornography to the murder. The specific search terms results were. Now I'm going to read a number, and as I read that number, this is how many times that search was performed. Body, 2083. Stab, 32. throat 2, bullet 10, DNA 3, fire 51, gas 50, rab 74. That's a big one. Gun 75, handcuff 2, bondage 3, blood 1, the entire 2. The Belly CD contains the state's recovered pornography images relevant to the Halbach murder. On the CD, Detective Belly refined 14,099 images on the 7 DVDs and recovered 1,625 violent pornography images that had been deleted. The CD contains thousands of images of violent pornography, criteria, word searches, registry, internet history, Windows history, and all MSN messages, all of which reveal a propensity for sexual violence. Without an evidentiary hearing, it cannot be conclusively established that Bobby was conducting these searches. Yet, Mr. Avery provided sufficient evidence concerning the schedules of the occupants of the Dassey residence to eliminate certain individuals who could have had access to the computer from many of the violent pornography searches. Mr. Avery has been unable to get an affidavit from Bobby admitting he conducted the searches, nor someone from the Dassey household stating they saw Bobby perform the searches, which the circuit court seems to be requiring. Moreover, Bobby did not volunteer for a forensic or psychological examination by Mr. Avery's experts, as the circuit court suggests is required. Based upon the findings of Mr. Gary Hunt, Mr. Avery's forensic computer expert, 667 sexual content searches were performed in total. Of those searches, 562 were performed on 10 weekdays between 6 a.m. to 3:30 p.m. August 16, 2005, 4 searches. 9/13/2005, 12 searches. February 23, 2005, 48 searches. 3/29/2006, 37 searches. 3/30/2006, 23 searches. 4/3/2006, 93 searches. 4/5/2006, 96 searches. 4/6/2006, 14 searches. 4/13/2006, 39 searches. 4/19/2006, 196 searches. Therefore, 64 sexual content searches were performed prior to Miss Halbach's murder between 6 a.m. to 3:45 p.m. when Bobby was allegedly home alone. If the family's reported schedules are taken to be true, another 500 searches were performed in the same time frame after the murder when Bobby was supposedly home alone. In its response to Mr. Avery's motion for post-conviction relief, the state conceded that Bobby is at least connected to 3 of the most violent searches prior to Miss Halbach's murder, and inadvertently conceded that Bobby is connected to 25 of the searches after Miss Halbach's murder. Bobby cannot be eliminated by the state from any of the pornographic searches, especially the ones conducted prior to and very close in time to Miss Halbach's murder, and he is the only family member who was seen with Miss Halbach's vehicle after her disappearance. The circuit court erroneously concluded that the searches done after Miss Halbach's murder have no weight. However, conduct of a suspected person after the crime is a legitimate subject for consideration as bearing upon the probability of his guilt. Motive can manifest itself after the crime when the perpetrator is reliving and fantasizing about the crime. The continued searches for violent pornography demonstrate that the motive for this murder was a sexual assault. It is highly significant that the searches for deceased mutilated young women began after, not before, the murder of mutilation of Miss Halbach. The searches after the murder coincide with the fact that a young woman was murdered and mutilated. The searches before the murder coincided with thousands of images of young women engaged in sexual activity, many unwilling, and corroborated a sexual assault motive. The circuit court also completely ignored Mr. Avery's evidence of the Dassey computer deletions, which infers a consciousness of guilt. Significantly, many of the Dassey computer searches had been deleted and only some of those were recovered, which leads to questions such as who in the Dassey household deleted the searches? Why were these searches deleted before Mr. Avery's trial? To make the proper credibility findings on this issue, an evidentiary hearing must be held. It is highly significant in any investigation if there is an attempt to delete or destroy records. In this sexual assault case, the appellate court found the defendant's consciousness of guilt was also evidenced as he told the victim to delete the text messages the two had exchanged, where the appellate court found that the fact that the jury heard evidence from which it could infer that Mercer, we're talking about a different case, you guys, Mercer deleted the files where the forensic examiners would have found the child pornography stored in his hard drive was significant evidence of the defendant's guilt. Mr. Hunt identified 8 times where there were deletions on the Dassey computer. Those deletions are very important because they correlate with Miss Halbach's visit to the property. Miss Halbach visited property August 22nd, 2005, and there were deletions on Dassey's computer from August 23rd through the 26th, 2005. She visited the property August 29th, 2005, and there are deletions from August 28th, 2005 through September 11th, 2005. She visited the property on September 19th, 2005, and there are deletions from September 14th, 2005 through September 15th, 2005. There are also deletions from September 24th, 2005 through October 24th, 2005. Most significantly, around the time of her murder on October 31st, 2005, there were deletions from October 26th, 2005 till November 2nd, 2005. Remember, everybody had to get the hell out of Dodge. Nobody had access to the computer anymore after November 2nd, right? Beginning November 3rd, 2005, there were deletions made on Dassey's computer. These deletions at the above described relevant time cannot simply be dismissed as mere coincidences. Well, maybe it was absurd. The circuit court misconstrued the holding in Dressler versus Cottery by adopting the state's argument that the pornography searches or images must be a mere image of the crime or they have no relevance. The court in Dressler made no such ruling and held that, quote, the pictures depicting violence were offered to prove Dressler's fascination with death and mutilation, and this trait of Dressler is undeniably probative of a motive, intent, or plan to commit a vicious murder. Likewise, here, most of the Dassey computer pornography consists of images depicting violence, even race car accidents that show a fascination with death and mutilation. And this trait of the Dassey I can't even say it. I've said it so many times I can't say it. Consumer is undeniably probative of motive, intent, or plan to commit a vicious murder. Mr. Avery provided the circuit court with specific searches on the Dassey computer of terms such as, quote, someone who was shot, and searches for, quote, gun to head. There were 8 searches prior to Miss Halbach's murder on 9/17/05 for, quote, skeleton and, quote, a live skeleton. After the murder, there were 6 searches for girl guts and 15 searches for girl hurt and 2 searches for seen bones hot girl. These searches mirror the fate of someone hurt, shot in the head, mutilated, and burned into skeletal remains, which is the total amount of information known about Miss Halbach's fate. More importantly, these images reveal the trait of Mr. Dassey's pornographic consumer that is probative of motive, intent, or plan to commit the vicious murder. Okay, hold on, you guys. We're going to stop right there because I am out of wind. I marked their place, right? Let's come up to the thumbnail. Let's see if I close this, what happens. There we go. Oh, my golly. I'm tired. This is so disturbing. You are so right, Rainbow. Seeking Rainbow said, so disturbing. Sassy says, ever since I learned the history of the corruption, starting with this case, I never take a Wisconsin case at face value or trust the narrative, nor anywhere else. Agreed, Sassy. Well, do you guys not remember when Brad Dassey went full-blown public saying that his mom, Bobby Dassey's mom, so Brad Dassey is Bobby's brother, older brother, he claimed he was ready to make an affidavit for Zellner or whoever, and I think he did, that Barb, the mother, was like, how do you delete a bunch of stuff off your computer and get rid of it? Right? Give you the goat. All right, get ready for those of you that don't like the goat. You're on headphones. Warning, you're about to hear a bloody scream. This is out of absolute frustration, and it's our trigger warning. All right? We gave it to you later because, obviously, if you come on my channel, I hope to God you realize this is an adult true crime channel, and this is always a trigger warning. So, hold on. I got to take a big drink. Hold on. I was drinking so fast I got an air bubble in my throat. It hurt. I love you guys. I really appreciate the support. For Stephen Avery. I had a lady go on in her comments and she feels Stephen Avery is guilty as hell. And, you know, I'm not opposed to listening to their side because everybody's opinion is valuable. And so I asked her, and we'll see what she says. I asked her, you know, why do you feel that way? Because I have literally worked with so many guilters over time. And, you know, it doesn't always work out, but there's times that I find out it's something that I can prove is not true. And then they take a minute. And some of them start realizing they are believing a bunch of bullshit. And then they become an activist for Stephen. And so, you know, we want to take that time and not always, you know, feel like we're being bullied just because somebody's like, he's guilty as hell. Just ask him, well, okay, why do you feel that way? Come on now. Are you talking about what? And, you know, some of them are like, I don't know. That's just what I think. Well, if you don't know, then why are you on my channel? Are you here to learn? Are you open-minded? Are you just some troll coming here to spread bad news? I mean, you got to really think about, if you're going to put it out there that you have an opinion and, you know, you're on a public site like ours, we're going to ask you why. And if you don't have a reason or want to come back with a comment, then what the hell are you putting it out there for anyway? I mean, we're happy to debate with you, and it'll be in all due respect. I'll treat you real nice. Always have. Aw, praying for Steve Avery. Yeah. Oh, chuckle darn, an air bubble. Ouch. Yeah, you know one of those where you swallow, you're chugging it through a straw, and you're like, drink, 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 and then, because my throat was so dry, and it was so yummy, and it's sweet tea, and it's chilly, you know, it tastes so yummy, and I drank so hard that a big swallow went down too fast when the other one hadn't gone down already. Oh yeah, there are guilters and there are those who believe he is 100% innocent. That is true. That is absolutely true. Justice for Stephen Avery, says Dreamweaver. It is time to wake the people. It is. So, we're going to be having a few late night talks. We are combining the old Rubber Ducky channel with this channel. So at night, sometimes, when we just want to get on here and put up a thumbnail like this and talk about Stephen Avery, we can, you know. Maybe go over a few documents here and there, show some things. But, you know, I'm going to have to break down, I guess, and go watch Candace Owens so I can go back at her. Because I think she's full of shit. But I can't fight her if I don't have her, you know, her version, and she's got it behind a paywall because she wants to make some money, right? I get it. I get it. You want to make some money. I'm not up against you. But the fact that, you know, you are like probably also censoring every comment, Like, I don't censor any comments unless they're personal to me. Like, if they make a comment about me, that's not fair. That's not fair. I don't talk about you personally. But if they're like, oh, this person is so guilty, I'm like, okay, if that's the way you feel, okay. But if you're like, you know, call me a name or something, you're gone. Sassy's like, it's a dream come true having Artie back. Yeah, I never left the case. I've been watching. All right, my beautifuls. We have been on here a little over an hour. I think it's time to get off here and let our mind rest, recharge our soul, our spirit, because, you know, we come back into true crime all fresh, and we get a lot further with fresh eyes, fresh views when we're recharged and well rested. And so I will see you again tomorrow night, and we will do part 3. I don't have any other videos going on tomorrow. I'm going to just leave it out there. I did do a little bit of a rant about the Idaho 4 case, as well as a little bit about Stephen Avery, about the trolls, ones that are just ugly as hell, you know, that have no respect. Like, you're not a troll if you disagree with me. You're a troll when you're a disrespectful asshole. Aw, Dreamweaver, you are amazing. You are amazing. Don't be calling me amazing. You amazing. I love you guys. You are amazing. You truly are. Let me get our music going. I hope you guys have a absolutely wonderful evening. Get some good rest. I can't wait. We're going to be bringing out a friend called Andre, and he's going to be joining us on our other channel very, very soon this month. We're going to have like a big kickoff. So you might want to check out Ancestors Speak in the near, well, soon, probably by February 1st. All right, with that, my lovelies, go watch all my videos. I thank you for the support. I thank you for the love, the likes. Leave your DNA on the like button, right? And I will see you again very soon. Love ya. To the moon and back. By the way, if you didn't do the crime, you sure the hell shouldn't be doing the time.